Greetings and welcome back for Criminal Justice 315 Criminal Evidence. This is the lecture for Chapter 3. In this chapter, we're going to be just talking about the adjudication process. And what I specifically mean by the adjudication process and what your book means is essentially the criminal procedure that a suspect goes through essentially from the time a suspect is deemed to be a suspect, i.e., has been thought of to have committed a crime from that point all the way to post-conviction up to appeal. As I've stated before in previous lectures, this is a 15-minute lecture, give or take a minute, so I won't be able to go through all of the material, especially for this chapter, because it's a little bit longer than some of the first two that we went through. But I want to make sure I hit on some very important parts, especially for those of you who are thinking about pursuing a career as a police officer or some sort of pretrial investigator, and then even those of you who want to do probation and parole work. You'll be doing a lot of things with the criminal trial that are very important. So I want to make sure that I hit on those topics for those of you who are going to be pursuing careers in that way. And if you decide to go to law school, well, then you're going to get a heavy dose of this stuff in more detail. So it's not necessarily, not that it's not important, it's just that for most of you are not going to go that route, so I don't want to get into the nitty-gritty there. So let's talk right off the bat with where does this all begin? The introduction to having a suspect, essentially. And that begins with this idea and kind of foreshadowing. An officer has some sort of suspicion that someone has committed a crime. Now, what that suspicion is really based on the facts and circumstances of every case. Sometimes it might be reasonable suspicion, and sometimes there might be legitimate probable cause to make an arrest right there and then. It all depends on what the officer has seen in his presence or what he can confirm after being informed of some sort of possible crime that is being committed. Once an officer initiates a stop based on whatever level of suspicion he has. If he has probable cause, he has enough suspicion at probable cause to make an arrest. If he stops with reasonable suspicion, he has to kind of develop that a little bit before it rises to the level of probable cause to make a formal arrest. But once a formal arrest has been done, then booking happens, the suspect is either placed in jail, or sometimes he or she might immediately go to a magistrate for a probable cause hearing. But let's assume, for purposes of this class, that the officer makes the arrest and books the suspect in the jail first. And then, after that process, we go into what is called the arraignment or the preliminary hearing, depending. We'll break that down. And your book starts off first with a criminal complaint, and I don't want you to think that that's not where it starts, but usually most states, North Carolina and West Virginia included, they're going to start with some sort of arraignment, whether or not there's probable cause to hold the suspect. And then the prosecutor is going to do some work to determine whether or not there's enough facts to initiate a criminal complaint. Very rarely do we just have a criminal complaint alleged. There usually has to be some sort of probable cause found first. So with the arraignment, that is usually reserved for small misdemeanor cases. In that situation, the suspect is presented before a judge. There's usually not a defense attorney there. There's only the prosecutor and the defendant at that point, or the suspect at that point. And we determine whether or not the suspect has a right to counsel. If the person does have a right to counsel, a right to an attorney, then we'll determine next whether or not they can afford one. And if they can't afford one, then they need to go get one, or they can waive it. Or if they can't afford one, then the court will appoint one, right? This is all that idea behind the Sixth Amendment of you have the right to counsel. Not every case are you entitled to the right to counsel. That arraignment is where it's determined whether or not you have a right to counsel. And usually that determination is determined based off the crime you were charged with. So, and again, we're not going to go too far into that, but if there's a right to counsel, we're going to determine we're going to determine whether or not you can afford one or if we have to appoint one. If you waive the right to counsel, then usually they'll try to handle the case right there and then. But if counsel is appointed or you elect to go hire your own attorney, then usually you get a continuance. The judge will say, we're going to continue this out, and you'll continue it for 30 days so that you have enough time to get in touch with whoever your attorney is going to be, whether that's an appointed one or one that you hire for yourself. And then when you return, usually the judge believes that it's the right time to go ahead and handle your case. Otherwise, then if you continue again, that's what causes that backlog, is the multiple continuances of one case. Usually a judge will grant one continuance and that's it. After that, you better have a good reason to continue your case again. But that's an attorney thing to worry about, not really so much a police officer thing to worry about. So there's probable cause. We got a criminal complaint issued. We've had an arraignment. Well, what's this preliminary hearing? Your book discusses a preliminary hearing. Sometimes, let's say, for example, that the suspect arrives to the arraignment, and at the arraignment it's determined that there's felony charges involved. And if there's felony charges involved, the judge is going to say, you know what, I'm going to continue this out, and we're going to reserve it for the felony case day. Or in some states where there's a bifurcation of district court and superior court, like in North Carolina, the bifurcation, the separation is what I mean. What happens is the judge says, I'm going to just continue this case out, and then whenever the superior court sessions are open, that's when the case will be taken care of. And the superior court sessions is what's called the preliminary hearing. The suspect will come in, sit down before the judge, or stand up before the judge. There'll be some evidence presented, because at this point the stakes are a lot higher, so we need to protect the defendant a little bit more. So some evidence will be presented, and the defendant will determine whether or not the suspect, and I apologize for interchanging defendant and suspect, but the judge will then determine whether or not the suspect, we have probable cause to keep that, and whether or not we believe he truly did commit this crime. And the reason, and you might be wondering, well, I thought we already did that earlier. Well, magistrate usually had done it earlier. And at this point, now we want someone with a little bit what we would consider a little more credibility, and that being superior court judge to really determine the nitty gritty, because sometimes magistrates aren't lawyers. They were never lawyers. They don't have a law degree. So even them, they might have some background in training and experience in what probable cause is, but we feel that the system is better protected by having a superior court judge determine again whether or not there's probable cause. So that's the preliminary hearing. That's the arraignment. And that's the criminal complaint itself is no different than any other complaint you may have heard of. It's really just saying count 1, count 2, count 3, and each one of those counts is a charged crime. And that count needs to state with specificity the location of where the crime occurred and the time it occurred, so that there's enough information there to say to the court, hey, court, you have jurisdiction over this crime. You have subject matter jurisdiction is what we will call that. Now, your book then goes into discussion a little bit about this grand jury thing. Sometimes the criminal complaint is not what's used to initiate a criminal case against a person. And sometimes we don't have a preliminary hearing. Sometimes we don't have an arraignment. Sometimes there's just enough information out there about this person that we want to issue a true bill of indictment. And in order to do that, you need to have a grand jury proceeding. So you've heard it all on the news before about, well, the grand jury issued a true bill of indictment. What that really means is that the person who is charged in the indictment has never been before a judge, has never been arrested. I'm not going to say never. Usually, the situation is where the suspect doesn't even know there's an investigation against them. The prosecutor and a lot of police investigation, undercover investigation has been undertaken by the government, and then all the information that has been discovered is presented before a grand jury. The defendant has no right to be at the grand jury, has no right to present a defense or anything of that nature. They have really no rights because it's determining whether or not probable cause exists. And once the grand jury determines that probable cause exists, they will issue a true bill of indictment. But please remember, the key part about a grand jury is that there is really no constitutional rights involved with a grand jury, meaning there's no constitutional right to defend yourself, to confront witnesses, to be present, to even have an attorney present, which means all of that, there's not even a Fifth Amendment right to self-incrimination. So you better be careful on what you say. You can go there and you can plead the Fifth, but that could potentially be used against you. Now, let's assume going forward, either the true bill of indictment has been issued, the judge has determined in the preliminary hearing that charges can go forward, at the arraignment there was probable cause, or that the criminal complaint went through all the necessary processes before judges, etc., and we determine that we can go forward with this. What happens next? Well, hopefully you have a really good defense attorney, because then the defense attorney is going to submit what's called motions to suppress, depending on what the crime is charged. Maybe there was a statement that was given by the suspect that incriminates the suspect. Maybe there might be an issue of Miranda there. And if there's a situation where Miranda would potentially exclude that statement, the defense attorney would file what's called a motion to suppress. Once a motion to suppress has been filed, it needs to be filed with what's called a notice of hearing or a calendar request, so that all parties involved, including the government and any potential witnesses, can know that there's a suppression hearing scheduled, and that everybody needs to report to court on this date before the judge to have an evidentiary hearing on this motion to suppress to determine whether or not the statement made by the suspect is inadmissible at trial. This could also relate to, evidence illegally seized by the government in violation of Fourth Amendment. And the other important part about all this, so you understand now that we're going to determine early on in the case what evidence is going to be allowed in. And usually the evidence that's the most incriminating is what most people are trying to suppress at the hearing. That's usually essentially the meat and potatoes of what most people are interested in having at these suppression hearings. And what's important is that, yes, the rules of evidence do apply, but they're laxed. So that means things like hearsay can come in even if they would be excluded by the rules of evidence. This is important to understand because essentially someone is going to hear something that's not allowed to be heard at trial, but they're going to hear it at the beginning anyways. I mean, potentially the judge could hear that the defendant did do it, that the defendant in fact did it, but that statement shouldn't be allowed in because it was obtained in violation of Miranda. And if that's the truth, well, guess what? It doesn't come in, but yet the judge has already heard it. So there's a little bit of strategy involved there. It's important to know that if you are a police officer or if you are a probation officer and there's a revocation hearing, there might be a potential that there might be a motion to suppress involved, because probation officers are law enforcement officers. So if a probation officer obtains something, a defense attorney might have an argument that it needs to be suppressed because it was obtained in violating some right of the defendant. Now, let's assume we're moving forward now. We've gone through all this process so far. We've gotten an order from the judge on his ruling or her ruling at the motion, the suppression hearing, and we now know what can and cannot be heard. But we want information that I can't obtain or you can't obtain. How do you do that? It's called discovery. We exchange information. Now, if I represent the defendant, what that really means is that I'm getting everything you pretty much have. I mean, I'm getting a blanket of everything I want. I just write down on a piece of paper and I serve it with you and I'm getting it. And if you don't give it to me, I have recourse with the court. Doesn't always work the same way with the government. And that's because we have Brady versus Maryland. Brady versus Maryland says any information that I think, and it says potentially exculpatory evidence, we're going to say any information that I think. If I think it's useful and it's exculpatory, you're going to have to give it to me. And that's what Brady versus Maryland in effect really creates, is that if the defense attorney thinks that it's going to be exculpatory, I'm going to get it. The government doesn't work the same way, but some state statutes do require reciprocal discovery. If I ask for it, I have to give you something of the same like and matter. We've gone through discovery. Now we've determined there might be some crimes here that are, let's just say that the evidence against my client is pretty high. And it's more likely than not that he's going to be convicted because you can prove it beyond a reasonable doubt. At that point, I want to initiate some plea bargaining on that charge, if you're willing to have it. Sometimes the prosecutor says no, but there will be plea bargaining. There's a lot of interest involved with plea bargaining, including the judicial system. It's backlogged. We don't want it to go to trial. 6% of cases go to trial. So that means there's a lot of plea bargaining going on. During plea bargaining, most of the time, if it's bargained, there's going to be charges dropped or charges pled down. If it's one charge, pled down most of the time. If there's multiple charges, it will be I plead guilty to these full charges, but you drop these other ones. And then we come to an agreement on the length. Key point and focus. Plea bargaining, if there's an agreement reached, guess what? It still doesn't matter because the judge has to accept it. If the judge says, I'm not accepting this, the case will go to court. Usually judges don't get involved, but it's important to understand that fact. Just because the two reach an agreement, it doesn't mean the court's going to accept it. Of course, once the plea bargaining phase is done, and if the parties can't reach an agreement, or if they reach an agreement to some, we plead on those, but then we determine on one charge, I don't really agree with you, prosecutor, and you don't agree with me, so let's go to trial on that one charge. Well, then we can do that still. We can plea bargain to some, and we can plea bargain. We'll go to trial. I'm not going to go through the specifics of a trial because by this time you should know what this information is, and you'll also get a good heavy dose of it here in the book. There is one last thing I want to touch on before I leave you for today, and that is sentencing. Guilt and sentencing are separated. They're bifurcated. It's the same way between district court and superior court. Imagine it the same way. Sentencing and guilt, they're separated. We're going to determine guilt, and once we determine guilt, we'll set a sentencing hearing at that point. The judge will usually set the hearing that day, the day the guilt or innocence is determined. Usually, the jury is not going to be present for sentencing unless it's a first degree or some sort of capital case. In that situation, sentencing, the jury will be there because usually evidence is put on that the prosecutor has to prove beyond reasonable doubt in order to get something like the death penalty. And but other than that, the jury won't be present. And what's important about sentencing and why I really want to go into this a little bit so you understand is that sentencing is the equivalent post-trial as the suppression hearing is to pre-trial, meaning the rules of evidence somewhat apply, but they are extremely relaxed, meaning that a lot of information can come in that wasn't allowed to come in during trial. In fact, you can actually bring up previous evidence that you used in the pre-trial hearing to use again in the post-trial hearing. Additionally, we have another player in the game at this point. Usually we're going to have a probation officer involved if the judge is considering probation, because then the judge is going to administer to the probation officer the job and the task of writing a pre-sentence investigation report. What that probation officer says in that pre-sentence investigation report is subject to cross-examination, meaning that I can call the probation officer up to the stand and cross-examine them about what their findings were in the pre-sentence investigation report. So that's a new player involved. That player usually wasn't involved in the trial or the pre-trial hearing. They may have been made aware of it and that there was a potential they'd get involved, but they aren't really heavily involved with the case until guilt or innocence is determined. At that point, then they're heavily involved, and now it's no longer really an issue. It's not really the defense attorney versus the prosecutor anymore. That's not the adversaries going at it anymore. It's really more or less the defense attorney trying to prove the probation officer wrong. And I'm trying to show that whatever's in the pre-sentence investigation report is not sufficient if the probation officer is trying to say that maybe probation is not appropriate and that maybe incarceration would be a better route to go. If that's the finding, then it's really going to be me versus the probation officer at that point. So with that being said, thank you for taking the time to watch this video. I'm sorry again that I went over a little bit, but there's a lot of good information here, and I wanted to go into some of this information in detail for you so you understand what it is I'm looking for, the type of things I want you to know, so you can be prepared for your test. If you have any questions, please let me know, and I look forward to seeing you on our next video.